Hi guys, welcome back. We're going to finish up with chapter 6 and talk about the rest of the excuse defenses and then just finish with a few other defenses that could possibly be raised to criminal liability. So it's pretty short, so we're just going to move through the rest of the PowerPoint. So in the last PowerPoint, we were talking about excuse defense. I did it, but I have a valid legal reason why I did it. And we mostly focused on the insanity defense. So lack of capacity, you don't have the mental capacity to form mens rea because you have mental insanity. So what we're going to talk about is the other excuse defenses today, okay? So another lack of capacity defense is what we call infancy. Infancy is the idea that your brain is still undeveloped because you're young and you don't have the ability to form mens rea because your brain isn't developed yet. Now, under common law, they had 3 different levels for infancy. Well, 2 levels for infancy and then adulthood. Okay, so under common law, if you were under the age of 7, they decided you could not ever form mens rea. Your brain was not developed and matured enough to ever possibly form mens rea. Then when you turn 7, all the way to the age of 15, you could have what's called juvenile delinquency. Juvenile delinquency is your brain is sort of formed, but it's not formed to the ability of you to form proper mens rea. You can kind of understand what you're doing, but you can't really be totally responsible for your actions. We're going to have a lower level of responsibility. That's juvenile delinquency. And then under common law, as soon as you turn 16, now your brain was considered formed and matured enough to form mens rea. So no more defense of infancy. Okay. Now, when you're in that delinquency phase, that middle ground, there is this concept called waiver to adult court. So we said it's juvenile delinquency and your charges would arise and be addressed in a juvenile court, in a New York family court. But we say there's some crimes that are so heinous that even if you are a juvenile delinquent, we're still going to try you as adults. So that's what we call a waiver to adult court. Traditionally, your case would be held in the juvenile court system, but since it's such a heinous crime, we're going to waive it to adult court, and now you're going to be tried in the adult court. So thinking about that, what factors would judges consider when deciding whether or not to take it out of juvenile court and put it into adult court? So kind of think about it. If you're a judge, what would make you want to try the person as an adult? And like I said, it's usually heinousness of the crime, how the crime was committed, number of people, the maturity of the actual child. So there'll be lots of things that the judge is going to think about whether or not they would waive this juvenile to adult court. So let's look at this example. KRL is an 8-year-old playing with friends. A neighbor told them to leave since she believed that they could get hurt. KRL at first says, in a minute, and the neighbor then insists they leave now and kind of yells at them. A week later, KRL goes into the neighbor's home, cuts up her goldfish and smears it on the counter, and then plugs in a curling iron and throws it into the toilet. Did KRL have the mental capacity to commit this crime? Should she be waived to adult court? So she's not under a 7, so there is some criminal liability, but she's under 15, so it would fall under juvenile delinquency. So she would be traditionally tried in the juvenile court system, the family courts in New York. But the question is, as a judge, considering all those things we just talked about, would you decide to waive her to adult court? Would you have her tried in adult court? Now, this is an opinion. This is a discretionary choice that judges make. So there's not really a right or wrong answer, but you would think through all those factors and the judge would have to ultimately make up a decision. So what I want you to do is look in the New York State penal law and see what the penal law says about infancy, what age we have now, and what offenses can be waived to adult court at what age. So look that up in the penal law. Make sure you understand subsection 1 and 2 of the infancy defense within the penal law. Now, other lack of capacity defense is intoxication. So intoxication is the idea that your mind is so either on alcohol or drugs that it cannot properly form mens rea. Now, when you're talking about intoxication, you have to distinguish between what we call voluntary intoxication and involuntary intoxication. If the person voluntarily chose to drink or do the drugs, that's one voluntary act. And hopefully you remember from Actus Reus, if you have one voluntary act, that's enough and it won't be a defense. So really, you're only going to see the lack of capacity intoxication for involuntary intoxication. So this is going to be cases where people's they were drugged or their drinks were spiked or something like that. It could also be that they just completely didn't know the effects that the medication was going to have. So it could be that they took the medication for one thing and they didn't know their body was going to react in that way. So that would be involuntary intoxication. I just saw a case not too long ago where a person was, every time they ate pasta, they had this rare medical condition that turned the pasta into alcohol. And the person was getting drunk from eating pasta. It was a special medical condition. And in that case, I would argue could be involuntary intoxication. Okay, so those are the lack of capacity. So insanity, infancy, intoxication. They cannot properly form mens rea. There are some additional excuse defenses that exist that I want to quickly talk about. So the first one is duress. So we said with necessity, it's like an outside force causing you to do something. So you have two bad evils. You have to choose the lesser of the two evils based on an outside force. Duress is similar. But it's an outside person making you do it, right? So you must rob the bank or I will harm your child. That's duress. So again, you have two bad things, your child being harmed and you have to rob a bank. But it's another person kind of making you make those choices. So that's the idea of duress. Now, just like necessity, you can never, ever use duress to harm another person. So if it's like you have to kill this person so that your child doesn't die, you cannot do it because the law cannot decide ever that one person's life is more important than another person's life. So don't ever use duress for physically harming another person. Then we have mistake. Mistake can be broken into two categories, mistake of law and mistake of fact. So think of mistake of law. You're speeding and you get pulled over and the police officer said, did you know the speed limit? And you said, no, I didn't know the speed limit. That's never going to be a defense. You are legally required to know what all the laws say. So mistake of law is generally not a defense. Mistake of fact may be. So if you believed the facts to be one thing, and which would not have been a crime, but you just made a mistake about those facts that does make it a crime, that may be a possible excuse. So I always use the example, my parents lived in Florida and they had golf carts and all golf carts had the same key. So one day my mother went to arts and crafts. She came home and my dad's like, that's not our golf cart. So she thought it was, they all look the same. They use the same key. And she took the golf cart, which is theft, right? Or larceny. But if the facts had been what she thought, it wouldn't have been because she would have taken her own golf cart. That could be a mistake of fact. And then the last one is entrapment. Entrapment is when the police get somebody to do something that they would not have done. That's the key. They would not have done. So if I walk up to somebody and say, can I buy drugs from you? And you say, sure, and you give me drugs, that's not entrapment. Even if I'm a police officer, I'm not forcing you to do something. You were going to voluntarily do it anyway. But if I go up and say, can I buy drugs? No. Please, can I buy drugs? No. I need them. And I just keep nagging you and nagging you and nagging you. And then finally, you just do it to get me off your back. That could be entrapment. So you got to make sure you're inducing somebody to do something they did not want to do for entrapment. Okay, so what about this example? The government informant befriends Sherman at a drug treatment center. He struck up a friendship and eventually asks him to get him heroin. Sherman, a heroin addict, refuses. After weeks of persistent begging, Sherman finally gives in and gives the informant some heroin. And then the police immediately arrest Sherman. Is that entrapment? And I would say yes, because he didn't want to do it. He didn't want to do it. He didn't want to do it. And then they forced him sort of into doing it. Okay, a couple other defenses I want to talk about, the syndrome defenses. So we talked about battered woman, battered child syndrome is often falls under justification defenses. Sometimes we have other sort of syndrome defenses that are signs or symptoms of some sort of disease or disturbance. These would not raise to the level of insanity, but people still have an understanding that the person is suffering mentally in some way. So some of the examples, premenstrual syndrome, PTSD syndrome. So those things like that, we know that there's something going on. We may allow, some states do allow these as defenses. And then the last defense we already talked about, we said it was a negative defense, is alibi. So don't forget, if you could ever show you could not have done it because you weren't there, you're negating actus reus, that's alibi, and that is also a valid defense. Okay, so we had justification, we had excuse defenses. There's one more category that I want to just quickly cover, and this is what we call procedural defenses. So procedural defenses are when the defendant doesn't admit one way or the other if they committed the crime, but they just said that the police or the judge or the prosecutors messed up. They did not follow constitutional protections. Somehow people in the system messed up. And since they messed up, we can no longer find the defendant guilty, criminally liable, because of the procedural problems. Now, remember, procedural problems are constitutional violations. So I always hear people say, oh, you got off on a technicality. Well, the technicality is the government not following the Constitution. That's a pretty big deal. And we think that the constitutional rights are so fundamental that we are going to allow the person to be not criminally liable because of the problems with the Constitution. So the first one's double jeopardy. You can't charge the person twice for the same offense. So that's always really important. If the jury finds them not guilty, we cannot find them guilty later once it's over and decided. We also have denial of speedy trial. That's a fundamental Sixth Amendment right that you have to be brought to a trial fairly quickly and not just be held for years and years and years and years. So that could be a procedural problem. And if their trial is delayed, the person could be let go. Prosecutorial misconduct could be that the prosecutor did something wrong. They didn't disclose information they were supposed to hand over to the defense, or they lied to the court or misled the jury. Those could be reasons why that a person would be found not guilty. And then you have police fraud, where the police could plant evidence, could lie on the stand, could do all kinds of bad things. And if that's the case, then we're not going to hold the defendant responsible because of those procedural errors. Okay? So that's pretty much the end of the defenses. What I want you to do is look at some what we call innovative defenses. So I want you to go online and write innovative defenses or crazy defenses, and find some examples of some crazy off-the-wall defenses. And that's your Chapter 6 discussion. Don't use any of the ones that we talked about in class. I want you to find other ones that are crazy and obscure that people have tried to use over the years. Okay? Real quick, you also have seen people use what are called trans panic or homophobic panic defenses, saying like, oh, I committed the crime because I was homophobic and I responded and I attacked somebody that was homosexual because of my panic about this. Some states have tried to preclude defendants from using these types of defenses. It's kind of an up and coming topic right now. Should these kind of defenses be permitted? So it's just kind of a thought-provoking thing, what you think of these defenses. Okay, and then the last thing I posted is I posted the Name That Defense practice. So you can print out the sheet, decide what the defense would be for each scenario, and then check it on the key to make sure that you really understand all of the defenses. So that's the rest of the lecture. And now it's time for your next exam. So the next exam is just covering defenses. So it's just chapters 4 and 5. So make sure you understand all your justification defenses, all your excuses defenses. And then when you're ready to roll, you can take exam number 3. Okay. If you have any questions in the meantime, please reach out. I'll be happy to answer any questions that you have prior to the exam. And otherwise, I will see you next week. Next week, we actually are going to move on and start to take everything that we learned and put it together in a special format. And then we're going to actually start talking about specific crimes. So have a great rest of your week, and I will see you next week.